So, Matt, what is the difference between joint legal custody and sole legal custody?
Joint legal custody means the legal responsibility to make decisions about a child's health, safety, education, and other major life decisions is shared equally between the parents. Meanwhile, sole custody is when one parent makes those decisions for the child. In Iowa, the courts prefer for the parents to have joint legal custody. So that's what you'll find is most common with parents in our schools.
Hey Matt, what's the difference between joint legal custody and primary physical placement?
At times, parents will talk to administrators about the fact that they may have joint legal custody of their child and will try to convince the administrator that they're able to visit their child at any time. When in fact, there's a difference between joint legal custody and situations where one parent has primary physical placement of the child and the other parent has visitation. So it's critical that you review court documents to determine whether or not, regardless of whether the parent has joint legal custody, whether or not they have visitation at the time to visit their child at school.
Matt, what is paternity and how is it established?
Paternity relates to the father of a child. In Iowa, paternity is established either by an action of the court, and often that will involve genetic or blood tests. 2, paternity may be established when both parents file an affidavit of paternity stating that an individual is the father. Or 3, paternity is established when a man is married to a woman at the time of the conception or birth of a child. It's safe to assume that if you have a birth certificate listing an individual as a father on the birth certificate, that individual is indeed the father until someone provides you with a court document stating that they are not. If paternity is not established, the sole legal custody of the child born to an unmarried parent belongs to the mother. So it's important that you ensure that you have something showing that the man is indeed the father of the child.
Matt, what are some tips regarding custody court orders?
Always double check to ensure you're following the most recent court order. If a parent, a grandparent, or another adult shares with you that there's been a more recent court order, let them know that the school will be following the order that it has in file and request that they provide you a copy of an updated order. If you're unsure as to whether or not an order is up to date, you may also check with the clerk of court, who would be able to let you know if there is a more up-to-date order, or in instances where there are questions about whether or not what's in the order is in the best educational interest of the child, do not hesitate to contact the judge whose name would be on the order to see if the judge would be able to talk to you about whether or not the order needs to be amended to ensure the child is getting his or her best education.
Matt, how does custody affect enrollment?
While we typically want to follow what's on the court order, the bottom line is we want to ensure that children in Iowa are being educated. So if you find that the individual, the student, is actually a resident in your district, I would encourage you to go ahead and enroll the student and allow the parents to work through the courts to figure out whether or not the court decides the child is to go to another district. Again, it's better to have that child in your schools than to be sitting at home where they would not be getting educated.
Matt, how should we handle visits by the parent who does not have primary physical care of a child?
I would encourage you to follow what's on the court order regarding when that parent has visitation of the child. However, use some common sense. So if the other parent had previously approved visits, such as a parent visiting for lunch, and the child, you had perhaps talked to a child that morning and the child had stated that he or she was looking forward to a parent visiting over lunch that day, then I'd go ahead and permit that visit, even if in the interim you were to receive a communication from the parent with primary physical care not to permit the visit. Also, when you have events such as award ceremonies, band concerts, or other activities that are open to the public, I'd encourage you to still allow a parent to attend those events regardless of what's on the court order. In some instances, you might have protective orders in place, and that's something different. So if you have a protective order or some other order which is specifically stating that a parent is not to be around a child or around other individuals, then that would trump what is on the older court order. Even if the parent with primary physical care has approved for the parent with visitation to visit the child during the school day, I would not allow that parent to take the child from the school unless the order states that at that time the individual has visitation, or unless the other parent has indeed approved for that parent to take the child from school. Also, there are times when issues come up about grandparents, where grandparents perhaps in the past have visited a child at school. I encourage you there again to follow what's on the court order and defer to the parent who has primary physical care or the parent who may have visitation during that time of the week. Defer to those parents and ask them whether or not the grandparent is permitted to visit. Now, Iowa law does have provisions for grandparents to be able to get visitation. So grandparents have the ability to address this with the court and perhaps get visitation of their own.
Are both parents able to review student records and attend conferences?
Unless you have something from the court stating that a parent does not have the ability to review records or to attend conferences, then it's safe to assume that both parents have equal access to a student's records, as well as both have the ability to attend student conferences. In addition, those individuals have the right to be able to approve for other individuals to review those records or to attend conferences with that parent or on that parent's behalf. I know there are situations that may arise where sometimes one parent or an ex-spouse is upset and does not perhaps wish for their ex-spouse's new boyfriend or girlfriend to attend a conference. However, you need to remember that that individual does not have authority to prevent that individual, the other individual, from attending the conference. So please ensure that you respect the rights of both parents, whether it relates to reviewing documents or attending conferences.
What is your recommendation when a parent wants staff members to write letters of support for custody hearings?
While staff members may write letters of support, I would not recommend them in most instances. Rather, I'd encourage your staff members to stick to the facts. They certainly may write something that relates to perhaps the attendance of a student or how that student has been doing in that teacher's class. But I would not encourage a staff member to write a letter where they're connecting dots to the relation of one of the parents or the other to the performance of that student. I believe that gets the school in a sticky situation, and it gets in the middle often of a custody battle. You're going to have one very upset parent that you're going to have to be dealing with. So again, I'd encourage you to stick to the facts, provide documents as those might be requested from the parents. Again, they both have rights to the records of those students. And otherwise, perhaps you might request for the attorney for the parents to issue a subpoena. That would be another way where they might be able to get the staff member to come forward to discuss their observations regarding a student.
What do we do if parents with joint legal custody disagree about an education-related decision?
If there's a disagreement between parents on an education-related decision, I'd encourage your staff members to make that decision that's in the best educational interest of the child. So just as the court looks out for the best interest of children, your school should be looking out for the best educational interest of students in your buildings. Now, when they're doing so, you do not need to agree with the parent who has primary physical care in every instance. Now, you might defer it sometimes to the observations of that parent who may have more time with the student, so that might be a factor that you consider. But the bottom line is your staff needs to make the education-related decision that's in the best interest of the child.